fluorine or something like that. I mean, this has real consequences to our health and to our society.
Okay, here are the questions. If our medicine is based on science, what does it mean for society if we can't have peer review? If you can't talk about some flaws in the security, vulnerabilities you found in some code, and if you're silenced with takedown notices, how are we ever going to improve any security and, for instance, in this case, better medical health? So open discussion is silenced, and I don't think the DMCA was meant for this, but it has become that.
So I'm going to give a little bit of background. This is the sort of dispute between Federici and this group called Advocates for Children in Therapy. This is all before Advocates for Children in Therapy, who's our current user, wound up on us now. So Federici is an alleged attachment therapist, which means that he treats something called reactive attachment disorder that I guess I could try and summarize it for you is basically, a child is deemed to not have an emotional connection to their parent, and so they misbehave, and this is called reactive attachment disorder. It's commonly diagnosed in adopted children, and so Federici has a proposed treatment for this therapy, where the person administering the treatment, sometimes the parent, sometimes the therapist, restrains the child, pins them down against their will for hours on end, and basically, I don't know, it seems like hugging and whatnot. It's weird, and then after all of this is done, after the child's been broken down, they go through this process to try and reform the bond. So Advocates for Children in Therapy is a group of people made up of nurses and psychologists and actually survivors, because this therapy has produced survivor groups, survivors of this type of therapy. They're trying to stop it. And so to give you some context, there's a Law and Order episode out there. I don't know if maybe some of you have seen it, but it's about a girl that's smothered in a blanket as part of a therapy session, and she dies. And that's based on the case of Candace Newmaker, who was a young girl that was suffocated and killed as a result of this treatment. So Federici legally engages Advocates for Children in Therapy for libel and slander because they're trying to stop his practice. So Advocates for Children in Therapy decides they're going to restructure their page so that people can draw their own conclusions. They're going to essentially make an academic argument and use quotes and whatnot. And this is partly because, because that's a good idea, and partly because truth is a protection for libel and slander. I'm going to give you an example of something that was DMCA'd off of. So this is one of Advocates for Children in Therapy's sites. So you can kind of clearly see that there's some quoted text over in this area, and then there's an academic citation, and it gives the page number, the publisher, everything that we were taught to do in school, and everything that copyright law clearly tells us is fair use. Enter the DMCA. Federici finds out about DMCA takedown notices, and he files a notice against Advocates for Children in Therapy, who are currently hosted or were hosted with this Ma and Pa hosting shop. So Advocates for Children in Therapy are kicked off of this Ma and Pa hosting shop without the ability to even file a counter notice. So they wind up moving to a large provider that will stand up for them, and they go to Network Solutions. Well, Federici files a takedown notice to Network Solutions, and again, they're kicked off without the ability to file a counter notice. And the significance of this time is that I guess the legal department at Network Solutions got involved and decided no, they shouldn't. I remember this is this content, right? They shouldn't have the ability to file a counter notice for this content. So Federici gets the content taken down, and they move to Project DoD.
And here's a legal procedure, and this is where it's taken, it's really been over a year that we've been trying to keep this content online, and it's really just, this is medical critique. It's not just our clients on Project DoD with ACT that are experiencing this, but leading magazines that, if they have bloggers from the magazine who are discussing attachment therapy, and with Dr. Federici's name associated with it, he gives them the takedown notices too. And they have a big legal department, so they fight it. But if you didn't have those type of legal resources, Going through this procedure on your own would be just very difficult. And well, here we go. So takedown notice is filed. The entire site comes down. So there's no critique anymore. ACT stuff is down. We allow for a counter notice. Take it down for 10 days. Content comes back up. The upstream provider gets harassed, and that's when we call the AFF for some assistance. And they were fantastic. AFF has been very helpful to us. They're not co-counsel, but they have been advising us on this case. So Federici has some other doctors send more takedown notices, and for the exact same stuff, for the exact same pages. This is not what the DMCA was intended for.
Yeah, and I just want to point out, too, that our major contribution at this point to censorship resistance is simply that we followed provision number 2 here, which is we allowed for the user to file a counter notice. In our experience at this point, the vast majority of internet service providers aren't even allowing this to take place. I'll give the exception to Google. They tend to do better with this, but most of the other internet service providers, as we'll show later, have problems with this.
So 6 months goes by. We're like, okay, great. Okay, maybe this is fine now. We're all right. And then Dr. Federici has an attorney in Virginia file a takedown notice for the same content again. So here we go again. So we now decide to use, that's it. We're going to fight this. We're going to waive the safe harbor provision. We're going 5112F, which means that if we win this, attorney's fees, I'm pro bono. Actually, all the attorneys on this have been pro bono. But if we win this, we get attorney's fees covered too. But it pretty much says that if you file takedown notices that you know are fraudulent, you can be held liable for that. So the arguments are made in main court, and they dismissed for lack of personal jurisdiction. It actually was a little procedural, kind of like a thing in the case that we are working on, but we are going to appeal in Virginia. That's coming up. So Federici files another DMC takedown notice, third time, same content, and we're now going to Virginia to pursue this. So common abuses for this. Fair use is not a magic bullet. It's a shame because under copyright law, one of the things that was really important, if you are going to be getting protection for your copyrighted material, you must allow for fair use. It's part of the trade-off. Just like for patents, you must make a disclosure of the secret thing that makes your thing special. But if you don't have fair use, there's some copyright material that you're not going to be able to access. So the statutory waiting period is equivalent to a denial of service attack now. I mean, that's similar to the one of the hypos that we used, as we've seen from the Google statistics as well, that we showed in an earlier slide. This is being used for corporate advantages, and this is not legitimate use of the DMCA. So the backdoor takedowns, Chris is going to talk a little bit about that as well, and this is an endless chain of attacks. If you didn't have a pro bono attorney, doing this for over a year becomes like a part-time job, and the ISPs aren't willing to take that on. So leveraging a counter notice to discover one's identity is another thing we've noticed that has been really unfortunate, is that this is something that, as an attorney, we didn't expect this, but any of the pro bono attorneys, shall I say any and all, that have assisted with this case, we've experienced some pretty serious online libel, and we can pretty much tell whoever is doing it has been pretty sloppy with the IP address. Again, we're also hackers as well. We, of course, all legal, but we've traced IP addresses, and it looks like this is related to this case. So all of the attorneys have had some problems with libel who associate themselves with this case, and that's unfortunate. But when we file a counter notice, sometimes there's some women who are trying to hide their identities because it seems like a lot of the libel is mostly toward the female attorneys on the case and the female plaintiffs. So there's a woman who would like to challenge this, but she's afraid of the type of libel that we've all experienced. And so having to reveal her identity has been something difficult, and in fact she decided not to join because of that, because for the counter notice it's something that we need to put on there. And the ISP's liability, this is difficult. Not all ISPs will do what Chris has done, so he's done a really great job standing up for this, and it's what Project DoD is all about.
Yeah, and I'll talk more about that later. Just that linking a disinterested third party that cares about profit to whether or not content stays up is just a bad idea.
We have Lentz versus Universal coming up. This is a case that EFF is working on in California. And if this case, I believe, is still in the appeals process, it's not complete yet. But we're hoping the resolution for that will be that you must consider fair use when you file the takedown notice. The complicated part of that, though, is to determine if it's fair use, you're most likely still going to have to go to court. Your ISP is not going to really, I shouldn't say is not, but most likely not going to stand up for you and analyze this stuff. Fair use is getting hard to determine as well. When you talk about, like, for music with sampling, and it becomes a legal argument. Did you take the heart of the copyrighted material? But in our case, we found it was a lot easier. You should be able to say a couple sentences from a book that someone has published, or from one of their public presentations. They said this. If it's properly attributed, that's fair use if you use it. And for critique purposes, it's even a stronger protection. So it's hard to use fair use as a defense against the DMCA, which is a shame, because it's not what the DMCA was supposed to do, I believe. But in our experience, 5112F is hard to use, and we have some jurisdictional issues with 5112F as well.
I know, which I think the jurisdictional issues are going to get interesting if there's the ACTA is passed, because then you're talking about takedown notices being filed from people in other countries. Where are you going to wind up resolving those cases? And
we've had that problem already. We're getting some stuff from Australia. As you know, you've perhaps been reading that Australia is becoming, the censorship there for material is becoming really challenging. So we're getting some takedown notices from Australia. We're thinking, wow, that's going to be really complicated, considering international law, how and if we're going to respond to that.
Another thing, too, that I just, when you guys leave the talk and you're looking at news articles online, is that when you see a lot of the, I think it's great that there are some wins happening against the DMCA at this point, but a lot of them are related to fair use, and just like Lens versus Universal was. But fair use is really something that you need to fight in court. It doesn't stop this sort of pre-court, guilty until proven innocent attack on people. And so it's great if you want to defend yourself in court, but the real trick, and trust me on this, is to stay out of court, period. It's time consuming, it's expensive, it takes forever, so we need something that helps people stay out and not be legally engaged. So I want to give some examples that we've come across of fair use abuse. In 2005, we hosted 2 domains, walmart-foundation.org and the 700club.org. We hosted them for about 2 weeks. They were, the 2 people that made the sites were part of a subversive media class at Carnegie Mellon University. And they had made the sites as a sort of social commentary on these 2 nonprofit organizations. There was a good satire. The articles were funny, but it had the same sort of look and feel, the same way you'd see like on The Daily Show or Colbert Report. Anyway, Walmart and the 700 Club filed DMCA takedown notices for this content. And of course, to maintain our safe harbor, we said, okay, well, the content has to come down, but you guys can file a counter notice. And these 2 users, they're students, they're art students. And they really struggled with the idea of trying to file this, because, of course, it's fair use that they have to defend. And if Walmart or the 700 Club wanted to take them to court, they'd be up against the legal might of those organizations. So fair use is tricky. It's tricky to use to defend this stuff. So the content went offline and never came back up. And so then the other one, of course, is Project DoD versus Federici. And by the way, the reason we covered Project DoD versus Federici in the beginning of the case is not only because it's interesting and we can talk about it and I think people will find it interesting, but Federici happens to hit every single abuse case that we're going to talk about. Like, he's really skilled at looking at this and finding, think of him, he's like a security researcher, but for law. So he finds all these flaws and winds up abusing them. But just further proof that fair use is hard to use, he started and engaged us after the Lens versus Universal finding, which said that, it's a misrepresentation, or I should say that it's a necessary precondition to the elements of